if you are, and I think we've had this discussion before. I have trouble with the concept of using the death penalty for a plea, and I recognize what we do in other criminal cases. But if the state's attorneys are using it in that manner, if you can't get the plea, is the intention to actually go forward with the usage of the death penalty? And if so, this just kind of, and I recognize you may not answer this given the way that you've been speaking about what our job is here to do, but if the case is that if you can't get the plea, you would go forward with the death penalty. You indicated to us that you would use the death penalty when there was overwhelming evidence and all of that, all of what you indicated earlier. Why would you, in that case, therefore, bother with the plea?
We don't use the death penalty as leverage to get a guilty plea, and we shouldn't use it, and that's not and I said earlier that that's not a reason to have a death penalty, so we can use it as leverage to get a guilty plea.
Right.
That'd be inappropriate.
Right, but in prior exchanges with me, you actually talked about it and having benefit that derives from the fact that it is a tool that could be used for that very purpose.
A result of it is that people who will not plead guilty unless they perceive a benefit in pleading guilty, there are people who will plead guilty in order to hopefully avoid the death penalty. Now, there are also people who plead guilty because they truly, I mean, I've had one case where, as I told you, well, not one case, I've had more than one, where people have honestly pled guilty. Honestly.
Can I just ask a point for clarification? Are you suggesting to me that people would plead guilty because they're worried about a death penalty that is not being held over their head?
No.
And I'm not being funny. Can you clarify what you're saying then? Because I'm having a hard time understanding. I suggested to you that the death penalty is held over an individual's head, and that's why they might plea. And I thought that was the discussion we had last year and the year before. You're suggesting to me that that's not how things work. That's not how things operate.
Well, I will tell you this, and this does happen. Defense attorneys will come in and say, "Look, I'm going to advise my client to plead guilty to capital felony if you won't seek the death penalty." There are cases where that happens, and there are that cases where we will say, "Okay, we won't seek the death penalty." Now, one of the reasons is the reason I talked about finality. We know what's going to happen if we seek the death penalty. It's going to go on and on and on. It was 21 years between the time Michael Ross killed Wendy Barrowbolt and the time he was executed. I watched what that family went through for 21 years. If somebody came in and said, "We'll plead guilty for capital felony," and I would think, and I remember very distinctly a case in which I really thought hard. I said, "Okay, I won't seek the death penalty if it's over."
Are you suggesting to me that the individual's counsel is the one who puts this forward, and you agree not to seek what you aren't going to seek anyway?
No, I'm not suggesting that. I am not suggesting that. If we decide, when we get a case in, the first thing we decide, we look at it. A, can we prove a capital felony? How strong is the evidence on each and every element of the capital felony? B, can we prove beyond a reasonable doubt an aggravating factor? If so, we decide to charge capital felony. We will then listen to anything the defense attorney has to produce or the defense produces about whether or not there's a mitigating factor or any other reason not to seek the death penalty. Part of that, obviously, is my client's willing to plead guilty and accept capital life or natural life. Of course we'll consider that, and we should consider that. We absolutely should consider that.
Thank you.
Representative